E ku iluna. Please rise. Ke noho nei ka aha ho'okolokolo ho'opi'i ku e. O ka luna kanawai hano o Catherine G. Leonard. A me ka luna kanawai hano o Sonia M.P. McCullen. A me ka luna kanawai hano o James H. Ashford. E ho'umalu nei. The Intermediate Court of Appeals is now in session. The Honorable Catherine G. Leonard, the Honorable Sonia M.P. McCullen, and the Honorable James H. Ashford presiding. E noho ilalo. Please be seated.
Please call the case.
Calling case number CAAP-21-0000412, Chantel Acol versus State of Hawaii Department of Human Services. Arguing for the appellant, Deputy Attorney General Skylar G. Cruz. Arguing for the appellees, Randall L.K.M. Rosenberg. Also appearing for the appellees, Brian M. Kaufman. Argument on the merits.
Good morning. Will you please state your appearances for the record?
Good morning, Your Honor. Skylar G. Cruz, Deputy Attorney General, appearing for defendant appellant State of Hawaii Department of Human Services.
Good morning, Your Honor. Randall Rosenberg and Brian Kaufman, appearing on behalf of plaintiff appellees.
Thank you. Please be seated. So before we begin, I just want to confirm, Mr. Cruz, you've requested 5 minutes for rebuttal.
That's correct, Your Honor.
And the yellow light will go on at that 5-minute time. And then at the end of your rebuttal, the red light will go on and you'll be done.
Thank you.
Okay. And Mr. Rosenberg, we're going to give you a yellow light just as a courtesy at 10 minutes. Thank you. All right. Mr. Cruz, would you like to
Yes, Your
come forward?
In 1997, 6-year-old Peter Boy Kema's life tragically came to an end due to the neglect and abuse of his own parents, Jalen Kema and Peter Kema Sr. More than 20 years later, on January 10th, 2018, Peter Boy's siblings Chantel, Alan, and Lena Acol brought this lawsuit on behalf of Peter Boy's estate and on their own behalf, asserting claims pursuant to Hawaii's wrongful death statute, Hawaii Revised Statute, Section 663-3. Now, Section 663-3 tells us who can bring a wrongful death claim.
Okay, can I stop you? Sorry. But the reason we had this oral argument is because I have questions specifically on this. Do we start with 663 or do we start at a higher level, which is, number one, the state is sovereign and starts with sovereign immunity, correct?
The state does have sovereign immunity, Your
Okay.
Honor, correct?
And then the next level down is, for what does the state waive its sovereign immunity? And are we looking at 661-1 and 5, or are we looking at 662-4 as our next level of analysis?
That's
Or
correct,
both?
Your Honor. And so those statutes that the court decided do provide waivers to the state sovereign immunity. And so, for example, the state waives sovereign immunity for certain tort claims. And we're not disputing that Section 663, a wrongful death action, is something that that the state has not waived its sovereign immunity for.
Okay, right. But when we're looking at what the statute of limitations is, don't we begin with the statute through which the state waives its sovereign immunity? Because as I read 661-5 and 662-4, they provide dates for which, and I'm not looking at them right now, but they say actions after the, 2 years after the accrual of the cause of action are barred. It's a hard bar. Is that correct?
I don't dispute the court's account of what the statute says. I would say that in this instance, however, where there is a specific statute that addresses a specific cause of action, as there is here, you would look to the statute of limitations under that statute and not a broader statute that might apply to a variety of claims such as negligence or negligent hiring, et cetera. So in this instance, while there is this higher level statute and statute of limitations within that, I believe the correct interpretation of the various statutory provisions at issue here, for purposes of determining the statute of limitations, is going to be the wrongful death statute 663-3.
So you would not agree with the fact that there is an absolute bar of all actions against the state under either 661-5 or 662-4?
I guess I'm a little unclear to me, Your Honor, what you mean by all actions, because clearly the state has waived its sovereign immunity for certain types of actions. So to the extent we're talking about, in this case, a wrongful death claim, there's clearly been a waiver for that. There's not been a waiver, for example, for intentional torts, assault and battery, things of that nature. The state has not waived its sovereign immunity for those types of claims.
Okay, so, and 662-4 is the statute of limitations for torts, correct?
That's my understanding, Your Honor.
And is wrongful death, as a wrongful death action, the tort?
I think that a wrongful death action is in the nature of a tort, is a tort-like claim. However, it is a statutorily created claim as opposed to a common law claim. Now, I think years ago, there may have been a common law action, a cause of action for wrongful death many, many years ago. But the state has, for many years, had a statutory provision which now establishes the cause of action and the requirements. For example, who can bring the claim, when the claim must be brought, and so on. And that is why, Your Honor, we look to that particular statute in this instance. I'm not sure that I've fully answered the court's question. I'm happy to continue if there's something that's unclear.
Well, I'm not really trying to trick you or make this hard for you, but I am trying to see this not only through the lens of 663-3, but, well, let's go with the State Torts Liability Act. I would think that there's at least an argument that could be made that 661 applies too, because 661-1 includes all claims against the state founded upon any statute of the state. And you'd have to agree that 663-3 is a statute of the state, right?
Yes, it is, Your Honor.
Okay, so that's why I asked you about 661-5, because 661-5 says every claim against the state cognizable under this part shall be forever barred unless the action is commenced within 2 years after the claim first accrues, provided the claim of persons under legal disability is not barred if the action is commenced within 1 year after the disability has ceased. So I'm wondering, since 663-3 is a statute, why we wouldn't look, for example, first to 661-5.
I think the way to view it, Your Honor, is, as I said earlier, that when we're talking about a particular type of claim or cause of action that has been granted pursuant to a statute, as opposed to just a general tort claim that isn't created pursuant to a specific statute. And I understand that there are a variety of claims that are created pursuant to statute, but those claims may or may not have a statute of limitations. Those statute of limitations, for example, in a medical malpractice claim, might parrot or parallel the accrual language in the 661-5, was it? But in this instance, this is a very unique type of cause of action because it is a wrongful death claim that involves different, I think, policy considerations. And so when you have a statute that has a specific language that differs from the other language in other statutes, we have to look at that language to determine the statute of limitations because it's specific to that claim. And we have to presume that the legislature was aware of these other statutes and these other statutory provisions providing statutes of limitations for a variety of causes of action where the state has waived its sovereign immunity.
Can we view 662-4 as being specific to the state? Because you're comparing the statutory construction specific in general. but 662-4 is specific to the state. So wouldn't that control?
Well, Your Honor, I don't believe it would. I understand what the court is getting at, that unlike 663-3, which is not specific to the state, 662-4, for example, is specific to the state. So the question is, why don't we look to that rather than 663-3? But again, when the legislature created the statute, it could have carved out an exception if it deemed it appropriate for claims against the state, and it could have included language in 663-3 to the effect of, except as otherwise provided with respect to claims against the state, the statute of limitations of 662-4 shall control, or something of that nature. But it chose not to do so.
Okay, so I think we'll have to let you get to 663-3, and I might as well throw a question out there about that statute and
Sure, let's-
see
I'm ready.
see where you can go with it. Okay, the last sentence of 663-3 is any action brought under this section shall be commenced within 2 years from the date of death of the injured person, except as otherwise provided, which gets me to 657-20, which is extension by fraudulent concealment, which very, very specifically says if any person who is liable to any of the actions mentioned in this part or 663-3 fraudulently conceals, and I think you know where I'm going on this, if there's a fraudulent concealment, the statute of limitations is extended under 65720. And I think maybe you could address that for us.
Absolutely, Your Honor. So that is correct. 657-20 does provide for tolling of the statute of limitations for up to 6 years where there's been a fraudulent concealment. There's no Hawaii case law that has specifically addressed this statute in the context of the wrongful death statute, but assuming that it does apply in this instance, or assuming that it does apply to wrongful death claims, the court should not apply the fraudulent concealment tolling in this case because the language in the statute says, quote, fraudulently conceals the existence of the cause of action, and it goes on from there. Here, the cause of action, there was sufficient evidence or knowledge by the plaintiffs of at least the existence of a cause of action long before the lawsuit was filed. And we detail these facts in our brief. I'll just highlight a few. But for example, plaintiff Lena Acol gave a report early on, about a year after Peter Boy's disappearance, that she had seen him dead in the closet.
What is the appropriate test? Because it's not existence of the death, it's the existence of the cause of action, right?
Correct, Your Honor.
What authority is your best authority for what we should be looking to?
Well, as I mentioned, Your Honor, unfortunately, there's no Hawaii authority, but if you look to the Al versus Al case, 663 Hawaii 210, the court discusses this statute, and it quotes a decision from the Michigan Supreme Court in Wiest v. Duffy. And the relevant language that I think applies here, that's helpful here, is that the court said, the fraudulent concealment which will postpone the operation of the statute must be the concealment of the fact that the plaintiff has a cause of action. If there is a known cause of action, there can be no fraudulent concealment. So it's not that the death may have been concealed in this case. It's whether the cause of action was concealed. And I believe that the record shows there's ample evidence to at least put the plaintiffs on notice that they should have known of the cause of action. And that leads me to another point, which we may get to later, which is that it's not the state's position that this lawsuit had to be filed within 2 years from the date of death. Because it's very clear from, I believe it's the Hun case, that 657-13 tolls the statute of limitations in the Wrongful Death Act to 2 years after the plaintiff reaches the age of majority.
Does that statute apply to the state?
That's what the Supreme Court in Hun found. Or I'm sorry, no, actually it was not the state, was it, in that case?
I think it's the Whittington case that my memory serves says that tolling statute does not apply to the state of Hawaii. That sounds familiar. I may be misremembering.
Your Honor.
Grin, so maybe he'll address him on his time.
Yeah, maybe, you know, I don't, I am familiar with the case, Your Honor. I don't recall the exact holding. But just you know, we're not taking the position that the, you know, state has sovereign immunity from the wrongful death claims or anything like that. We're not taking the position that the minor tolling provision doesn't apply to the state. If there is that authority that says it doesn't, then
So be it.
so be it, yes.
Since I've hijacked the questioning, I apologize to the other judges while I took the floor. Can you have a cause of action or have the opportunity to bring it if you don't know that that Peter Boy was dead? In other words, don't you have to know about his death to have the cause of action accrue?
I think that, Your Honor, I think you're asking one of the central questions in this lawsuit.
Where's the answer, yes or no?
The answer, I think the short answer is no, and I'll explain.
Okay, please do.
Okay, so this goes to, I think there's two parts to the analysis. The first starts with the statutory language. The language doesn't make the statute of limitations contingent upon knowledge of the date of death. It simply says
But
date
you
of,
still have to have a death, right?
correct?
Okay, so until he's dead, there's no cause of action, right?
I would respectfully disagree, Your Honor. The analysis is that, you know, there has to be sufficient knowledge to bring the cause of action. Sorry, no, I misstated that. The the analysis is that the cause of action has to be brought within 2 years of the date of death. And so here, for example, the plaintiffs had enough information to know there was at least a cause of action. Whether or not Peter Boy was dead was something that could have been proved by the appropriate standard in a civil action by a preponderance of the evidence. It's akin to, for example, in a childhood sexual assault case, where oftentimes there is no physical evidence by the time the lawsuit is brought.
But
And
if
so,
there's no death, they're gonna, if they don't prove death at trial, they lose, right? For a wrongful death claim?
that would be one of the elements that would have to be proven.
Sorry,
It would and that's, Your Honor, and that's two points, which is,
My apologies, I'll bring it closer. Okay, sorry, continue.
correct, there has to be death, it has to be wrongful. Those are both things or elements that would have to be proved in a civil action. And that would require, of course, presenting evidence and having a finder of fact to make that determination. We could look at it another way. What if in this case, we knew Peter Boy was dead, but we didn't know it was wrongful? Would we then extend the statute of limitations indefinitely until we knew it was wrongful? I think the answer is no. That's the purpose of discovery. You file your lawsuit during the limitations period, and then you do the discovery to determine, was death wrong? Was there a death? Was it a wrongful death?
Well, let me just interject one thing. Isn't this a question of fact as to whether or not you could have been known or knew or should have known? I mean, why, on what basis are you saying that this should have been decided as a matter of law in favor of the state?
In this case, we would argue that, again, there was sufficient information available to the plaintiffs to know long before the cause of action was filed, not whether he was dead or whether death was wrongful, but that there was a cause of action that needed to be filed within the statute of limitations period. So that's the issue here. So that's not an issue of fact. If there is an issue of fact, if the court disagrees with that analysis, then perhaps it should go back for the finder of fact to determine those matters. But we would argue that those issues of fact are not relevant to the analysis of whether the lawsuit was timely here, that the evidence shows, the record establishes that it was not. I'm happy to answer any other questions before I move on, but otherwise, okay. You know, I'd like to also point out to the court that, as I said earlier, that Hawaii's wrongful death statute has been around for a very long time. It has been amended multiple times over the last 100 years. It was last amended in 1997. The legislature expanded the statute at that time to add reciprocal beneficiaries as enumerated persons entitled to recover under the statute. This was actually 3 years after the Leah Matafau case, which we may discuss if we discuss the standing issue. And so, again, if the legislature had concerns about the language of the statute, it could have addressed it then when it was amending the statute. It could have addressed it at any other times in the 20 years since the last time the legislature amended the statute. And so, as I mentioned, this statute was addressed and considered by the court, or construed by the court in the Leah Matafau case. This was in the context of standing. And I think it's important to note, although the court was not looking at the statute of limitations in that case, it was looking at the question of classes of persons permitted to bring a cause of action. It stated, quote, "The language of 663-3 is plain and unambiguous." And it repeated that a couple more times throughout the decision. And so the question in Leah Matafau was whether the deceased longtime girlfriend and her son could bring claims as persons wholly or partly dependent upon the deceased. The court began by pointing out that the plaintiffs had alleged that they were wholly dependent upon the deceased. The court, citing the Young decision, found that the term dependent connotes the existence of necessitous want, such as physical, moral, and social necessities. So physical necessities is discussed in the decision, and it's pretty clear: food, shelter, clothing. The decision is a little less clear, and the court does not fully explain what it means by moral or social necessities, but the decision provides a helpful clue. The example that the court gave in Leah Matafau was education. That's an example of a moral or social necessity. And this is a lot like food and shelter and clothing in the sense that it's the type of necessity that a parent provides a child. And the court goes on to say that there are other readily conceivable subjects, although it doesn't tell us what those are. But one could easily imagine things like taking a child to a doctor's appointment, providing school supplies, coaching a sports team. But in this case, the plaintiffs only allege that they were dependent upon Peter Boy for love and affection and emotional support. There is no allegation or evidence that Peter Boy's siblings were dependent upon him for anything that could be considered a physical, moral, or social necessity, as that term has been construed by the Hawaii Supreme Court.
So are you saying that we can determine as a matter of law that there's no moral and social necessities here in this case?
Yes, Your Honor. I think it's very clear from the record.
And what law am I relying on in determining that?
Again, this would be the Leah Matafau case. And
It does not necessarily eliminate that. I mean, weren't they looking at the facts of the case and someone has to decide it, right? Is that something, it's not in the statute, correct?
The statute does not, no, there's no definition in the statute.
Okay, so
So we look
doesn't
at-
a fact finder have to make facts on that and decide whether or not the allegations and ultimately the testimony of the Acols meets that criteria?
Your Honor, I don't believe it is an issue of fact here. I think that the law is clear about what wholly or partly dependent means, and it was explained by the Hawaii Supreme Court. To accept plaintiff's position would be to extend the class of persons permitted to bring wrongful death claims well beyond what was contemplated by the legislature and embodied in the statute. Interpreting the statute so broadly would give anyone the right to sue for a wrongful death, the wrongful death of anyone else that they had love and affection and emotional support with. This could include aunts and uncles, grandparents, and even close friends. And to go that far would be to go well beyond what is contemplated under the plain language of the statute.
How do you know that goes beyond what was contemplated? We all Supreme Court. So all we have is what's written, and it does say any of the persons, and it says with reference to loss of love and affection. That seems incredibly broad to me. They used words like any of the persons and loss of love and affection. That seems incredibly broad. Sorry to repeat myself, but how do you know that that would go beyond what was contemplated?
Your Honor, I think the way to look at it is the loss of love and affection and emotional support. Those types of things go to the damages that can be recovered.
Are those social wants or social needs?
Those are simply just the damages, the injury, the harms. But
So,
the social,
I don't want love and I don't want affection, because those are not wants, you just said.
those are harms, but the wants would be the things that you depend upon someone for.
Like love and affection.
But that would not be, I think, within the class of items that's either in the language of the statute or as described by the Supreme Court in the Lei Matafao case. I think that this court have to read something into the language of both the statute and the case that's just not there.
Well, I'm just reading this,
The-
I'm quoting the
it says-
statute. I'm sorry, you can go.
It says including loss of society, companionship, comfort, and the word including kind of means it's not exclusive, this list, that there could be other things. And that's just the plain language.
Again, as I read the statute, Your Honor, I see that as including what is available for the plaintiffs to recover. But in terms of how the Supreme Court has construed the statute, it's both in the Young case and then in Lei Matafao when the Supreme Court revisited this question. We have to look at how the court has construed dependency in these cases. And it did so by, again, looking at something like a necessitous want. And again, it goes to things like food and shelter and clothing. And in this case, there's clearly no evidence that that Peter Boy provided any of those things to his
Can I
siblings.
ask a question on that? Because this second time you brought up a lack of evidence basically of standing. Why would the record be fully developed factually on standing if it wasn't raised until appeal?
The standing issue, it starts with the allegations in the complaint. The plaintiffs do not allege that they were dependent upon Peter Boy for anything such as food, shelter.
Do they have to allege standing under Reyes-Toledo and Rule 8? I mean, all the facts to prove standing? They have to put that in the complaint?
I think that it is something that has to, at least at a base level, be alleged, and the facts have to be alleged in the complaint. And I think at this point, Your Honor, the record is sufficiently developed in order for this court to decide the issue because this was decided on summary judgment. The plaintiffs, if they needed additional facts to establish standing.
Did you attack standing on summary judgment? Was it raised by anyone, the judge, attorneys, anyone?
You're right, Your Honor. I take that back. It was not raised in summary judgment.
So that was my question is, why would the record be fully developed such that summary judgment is appropriate or on appeal to say there's no standing when nobody talked about standing until you filed your opening brief?
I understand the court's concern. And again, I would say that there is sufficient evidence at this point in the record for the court to decide the issue. But if the court were to find that there's not, the case could be remanded to develop those facts.
Thank you, Mr. Cruz.
Thank you, Your Honor.
Thanks.
Mr. Rosenberg.
Thank you. Obviously, I had something prepared, but based on the court's questions, I kind of feel like I should focus in on those same issues, unless the court wants to direct me in another direction. But let me address some of the things that have come up so far, just so that you understand at least what our position is on those issues. Let's start with the most recent, since it's fresh in everybody's mind, and that is the notion that Laialai Matafao is a case that we're dealing with sort of in an unusual situation on appeal, and there has not been a chance to develop the record below. We did not allege, we didn't use the word dependency when we drafted the complaint. I agree that that's the case. However, in the matter that was, the case that was cited by Judge Ashford, which is Bank of America versus Reyes-Toledo, it's a notice pleading, and the court is well familiar with that, but let me just read the quote, just because I brought it with me, just in case. And it says, the Supreme Court of Hawaii has rejected the approach that pleading is a game of skill in which one misstep by counsel may be decisive to the outcome, and in turn accepted the principle that the purpose of pleading is to facilitate a proper decision on the merits. Now, we can go back and we can amend the complaint, but I would submit that there's plenty in there. We cited the wrongful death statute. We lifted a lot of the language from the wrongful death statute when we pled what the damages were and what the interruption of and what the claim was based on. So although we didn't use the word dependency, and we can do that, I feel that under the case law that we have here, it's not necessary.
Well, let me just ask you, do you agree with Mr. Cruz that we can address the issue of standing as a matter of law on appeal
So I
when
don't,
it wasn't raised below?
they've cited case law that seems to suggest that standing is a jurisdictional issue, and that it can be raised for the first time on appeal. I don't think we have a fully developed record. I will have to prove, if this case goes to trial, I will have to prove the relationship, that it meets the standard that we're talking about in Lealai Matafau, and that will be up to the trial judge to determine. And so there is nothing at this stage that we have that would require the dismissal of those survivors' claims, derivative claims of the siblings. The estate claim, of course, has nothing to do with Lealai Matafau. That's going to continue regardless. But with respect to the siblings' claims, I still have to go back and prove my case. No question about it. I don't think it's appropriate to deal with it in a summary fashion here. That would be my answer, Your Honor. Let me address briefly.
Just to clarify, though,
Sure.
Tax Foundation said standing is not jurisdictional.
I'm sorry?
Just to clarify, Tax Foundation said standing's not jurisdictional.
What they've cited in their memo is that they believe they can raise this for the first time in appeal because it deals with subject matter jurisdiction. And so the way this comes up,
Right, and I think what Judge McCullen is trying to say is that the case Tax Foundation of Hawaii versus State 144 Hawaii 175 says and this is a quote, in Hawaii state courts, standing is not an issue of subject matter jurisdiction, but arises only out of judiciability concerns based on prudential concerns of judicial self-governance. And that's a 2019 case. And I think the references that the state's brief included maybe predated that.
I see, Your Honor, in which case I will accept your correction as to the law on that matter, Judge. Now, with one last thing on Lealai Matafau, and that is where we find ourselves here, because again, it was added after, and as Judge Ashford pointed out, there has been no development of that issue on the record. But to be fair also, we haven't really had a full chance to argue that because they didn't cite it in their opening brief, even though that was the controlling case on the wrongful death category argument they were making. So they didn't actually argue it until I pointed out that this was an important case, and I didn't know where they were coming from on that because they hadn't addressed it yet. So certainly we would ask if the court's inclined not to allow that argument to be made, that's of course acceptable to us. But more importantly, if it is an issue that the court is concerned about, it should be sent back and we can develop the record and do what's necessary to make sure that we've met the legal requirements for those claims. Is there any further questions on that? Thank you. The court noted earlier that HRS 662-4 is a statute that is included in the State Liability Tort Act, and that is important, and I've argued that in our brief, and the reason that it's important in our opinion is because it is a higher level than the wrongful death statute in many ways, and so it says that tort cases have a 2-year accrual. It's 2 years from the accrual of the cause of action, and that's, I think, important to understand because they've been arguing that there's no accrual argument here, there's no accrual issue, that the wrongful death statute is clear on its face, it doesn't permit the accrual of the cause of action. But then he argues about the accrual anyways, and this is what he says. He says that, first of all, they should have known there was a death, or they knew there was a death and they didn't pursue it to discover that there was an actual death. Then he also says that they should have pursued a wrongful act, that they should have figured out in discovery that there was a wrongful act. So what he's suggesting is that they should have hired an attorney without a death and without evidence of a wrongful act and asked the attorney to file the lawsuit and then during the discovery figure out if they actually had a cause of action. ridiculous. That is not how we work. I've been doing this for a long time.
Mr. Rosenberg, when does a tort cause of action accrue under 662-4?
It doesn't say, but the word accrual
Isn't there
means,
case law that says?
well, we didn't cite specific case law on that point, but we do know what the discovery rule says, and in different contexts, there are different rules for determining when a cause of action accrues. We've argued that for purposes of 663, the wrongful death statute, it accrues when you have a death, which is wrongful, you identify the defendant who committed the wrongful act, and you have the nexus between the wrongful act and the death. And we believe that's what the law establishes. And so without those three things, what I've called in the past a three-legged stool, without all three legs, they can't argue that it's accrued. This didn't accrue until the family knew, the siblings knew that Peter Boy was dead, which wasn't until 2016, that he was killed by the parents, which they also learned in 2016, and the circumstances in which he was killed, so that there was a nexus between the wrongful act and the death. With respect to the state, that didn't come up. We didn't know that information until the special master report, because the special master was able to get documents that neither the family or the prosecutor's office had.
Mr. Rosenberg, so regarding that, there's affidavits attached to your motion for summary judgment from Alan and Chantel regarding not being aware until the special master's report.
Correct.
There's nothing like that in Lena's affidavit.
I'm sorry, Selena did submit an affidavit, and what she described in her affidavit was that she had had a number of childhood hazy memories.
But I'm talking about the state's, the special master's report and the state's role in everything. And there's no, I guess, was there any evidence that Lena didn't know about the state's role attached to your motion for summary judgment?
Yeah, so she wouldn't have known anything about the state's liability.
But is there any evidence presented with your motion for summary judgment
Is there any evidence of the state's liability?
of Lena's knowledge or lack of knowledge of the state's liability?
Yeah, I don't think that her affidavit addressed that at all,
Right.
but there would be no reason for her to have any knowledge because the state's liability was encompassed in
But
documents
it's
that
your
were internal.
burden to present that. It's your initial burden for summary judgment, right?
Yes, for our motion for summary judgment, it is. Yes, Your Honor, but I cited where the information came from. That information was not available to Lena or to any of the siblings as they said in their affidavits. And so, and I'm the attorney that represented them. I got the information at the same time they did. That's how they got the information, through me. So this is how the case was conducted. That information all involved internal documents. There's no way that anybody knew about any of that stuff until the special master did his initial investigation, and then when we started getting discovery. Any questions about how we feel about 662-4? Shall I move on?
Go ahead.
Thank you. Let me talk just briefly about fraudulent concealment. We believe that that provides an independent basis for defeating the statute of limitations argument. The court's already talked a little bit about that. The state admitted that the chemists fraudulently concealed the evidence of what they had done. They concealed the fact that Peter Boy was dead. They concealed the fact that they murdered him. They concealed the fact that they disposed of the body. There was nothing. So the question really is, does the plaintiff get harmed by that extended statute only applying to the chemists? Or does it apply to everybody who's involved, all the co-defendants? And I would submit that the principles of tort law, fundamental fairness, they don't get the benefit. The state does not get the benefit of their co-defendants' fraud. Try and say, now it's too late because you didn't know, you didn't figure it out. It's too late for you.
Do we need to go beyond the language of the statute to reach that? Do we need to go to policy arguments?
I don't think so, but I'll take it any way that you want to give it to me. I think it's clear on the law, but I'm not wearing the black robe today.
Okay, so you agree 662-4 applies, right? Even
I
if,
think it does.
okay, so 662, and this is where I started with Mr. Cruz, was that 662-4 has a hard deadline, which is a tort claim shall forever be barred unless action is begun within 2 years after the claim accrues. Now, I don't know that this matters so much on the appeal. It may matter once more facts are brought out if this case is remanded. But don't you think that 2 years after accrual is a hard bar that would trump, if you will, the 6 years under 657-20?
I don't know.
Okay.
I
But you
wanna-
would agree the state is sovereign as a,
Of course.
and that we're talking about a statute that waives sovereign immunity, and that if it's not waived, you can't proceed.
That certainly is an argument, Your Honor. All I would suggest, in perhaps opposition to that, is that we're talking about very specific behavior and a very specific statute. And we find in all kinds of civil cases that fraud changes everything. When a party commits fraud, there's all kinds of remedies to put the plaintiff in the position they should have been had that party not committed the fraud. And here, I think that the same thing should be recognized. And they've admitted that that happened. There's no dispute about that. So I think that the court should, in fact, find that there was fraudulent concealment, but I'll leave that up to you folks to decide. I do want to mention Whittington briefly because Judge Ashford brought it up. Whittington was a decision that came out in 1991. I have copies of it here if anybody needs it. I'd be happy to provide it to opposing counsel. I wasn't sure if that was something I was going to talk about today. But Whittington basically, a 1991 decision, which said that the state is not subject to the minority tolling position. They followed federal law on that because the federal government has instituted that same doctrine. And I don't like it. But the fact of the matter is these kids could not possibly have filed a claim if Whittington is the law in Hawaii, which it has been for a long time. So the arguments that the state makes that, oh, well, there's enough there. When Lena turned 6, she should have gone to get a lawyer and explain that, they put him in a box and buried him under a tree when that's not even what happened. She made a lot of mistakes. She said she talked to him on the phone after he disappeared. He was in Honolulu with Auntie. She said that she put a water hose in his mouth when he was lying in the bathtub, dead. That never happened. She said, oh, I was kidding about that. She was 4, talking about things that happened when she was 3.5. The prosecutor, Mr. Damerville, wrote an affidavit explaining how difficult it was to sort through her testimony. So for them to try and argue, not only should she have realized that the parents killed him, which she's never talked about, but that she should have, within 2 years of that knowledge, hired herself a lawyer to pursue her claims and the estate's claims. It's just absurd. The last point, Your Honor, that I would like to make, unless there are other questions, is equitable estoppel. And if ever a case screamed out for it, if you find against us on all the other two grounds that were given to us by Judge Tanaki, I would urge you to look at equitable estoppel differently. This is a case that screams out for that. It's often applied against a statute of limitations defense. We have Hawaii case law on that. We believe that it's very appropriate here. They were wards of the state. They went from foster home to foster home for years. They had no ability to file anything. The state had no interest in helping them. And that's just how it went. 20 years later, we're able to get this thing filed, and they deserve redress. They deserve justice.
Sorry, we're going off track, but I want to revert to something you said earlier in response to Judge Leonard's question, sorry. Are you taking the position today that the applicable statute of limitations is 662-4 and not 663-3?
Your Honor, I've argued both, and which one is if one outweighs the other, it's hard for me to say. If I was looking at it from the state, I would always start with the State Tort Liability Act, right?
So
I
you're not
agree.
really taking a position on which applies, you're arguing the application of both depending upon what we decide applies.
I've argued that both statutes require accrual, and that accrual is not present here until the three legs of the stool have been established, and they just were not. So whether you choose 662-4 or 663-3, to me, we get to the same place, the same argument.
Thanks.
With that, I have nothing. Oh, I'm sorry.
Okay, so, but 663-3 is not an accrual statute by itself, correct?
Well, it doesn't have the language, but I have argued that it is in fact an accrual statute because it requires a wrongful death. And in cases where that was not obvious from the beginning, they made exceptions, and that's the Collins versus Sotka case. It's the helicopter case, situations where it was not possible to know whether the person was dead and how they died. So a good example is obviously the Collins case. Collins case, it was a murder. Nobody knew what the facts were. Nobody knew who did it. They finally found somebody and prosecuted, and the facts were established during the criminal case. And that's when the court ruled that that was when the statute, when the wrongful death cause of action actually accrued. In the helicopter case, you're in Alaska, helicopter takes off with a bunch of passengers on board and it disappears. 8 years later, they find the wreckage. Everybody on board is dead, and they find that the cause of the helicopter crashing was a mechanical failure, and it was tied to a particular part that was defective. 8 years after the fact, the court said, how could they possibly have been able to file a wrongful death case before that? They didn't even know that these people were dead, and they didn't know what the cause was. So the court extended that with the same wrongful death statute that we have here. So what I'm suggesting, Your Honor, is that either statute requires sufficient knowledge for the cause of action to have accrued or arisen.
Thank you.
Thank you.
No.
Thank you very much.
Thank you.
Thank you again, Your Honors. I'd just like to address a couple of points. I'll keep this very brief. As I argued earlier, we believe that the statute of limitations in 663-3 is the statute of limitations that applies here. If the court, however, were to find that it's 662-4, then again, we would argue that there was enough information available to at least Lena, if not all of the siblings, that they should have known that the cause of action accrued long before the lawsuit was filed. And because the lawsuit was not filed until decades later, those claims are forever barred.
Mr. Cruz, I have a question. So, and this is regarding the special and master's report. There's two, I guess, reportings mentioned in there. And one was late 1996, early 1997 by grandfather. And the second one was April 1997. And that was by 15-year-old cousin. Now let's assume that the plaintiffs met their summary judgment burden and the burden shifted to you, the state. Did the state show specific facts in any of the summary judgment filings that the siblings were aware of those two reportings?
Of the two reportings,
The late 1996, early 1997, and the April 1997.
I think in order for the state to prevail on summary judgment, it wouldn't be necessary for the state to show that the awareness of those specific reportings because there was other information that was available. Again, the reports made by Lena herself, the fact that there was an investigation, ongoing investigation by the police looking into the disappearance.
But that deals with the death. The two reportings I'm talking about kind of goes to negligence of the state.
Oh, I understand. I think what the question is getting at is something akin to how could plaintiffs have known that they needed to sue the state if they didn't know about these reports or something along those lines. And I think that the way to look at this is that
Well,
we
I
don't-
guess my question is, did the state, for summary judgment purposes, provide the circuit court with specific facts that these siblings were aware of those two reportings?
I'm sorry, in order to bring the claims or in order to prove the negligence?
For negligence.
I'm not sure, Your Honor, if that was made, if that evidence was presented in the briefing. Again, I would just say that for purposes of bringing the wrongful death claim, there was enough information available, and even if the plaintiffs did not know of the negligence of the state, that could have been fleshed out through discovery, and those reports could have been discovered by the plaintiffs. As far as Mr. Rosenberg's discussion of the various cases from other jurisdictions on 663-3, or in other words, or not that statute, but the wrongful death statutes, I think first, the United States District Court for the District of Hawaii has looked at this statute and found that the language there is plain and unambiguous. It's not an accrual statute. And at the risk of repeating myself, this case is distinct. I see I'm out of time. I don't know if I
Go
may.
ahead, finish your
Okay.
thought.
That what distinguishes this case from, say, the Alaska case, for example, is that in the Alaska case, the pilot took off and was just never seen from again. But here, there were reports and other information that would at least have put the plaintiffs on notice that something was wrong, that something had happened.
Thank you, Mr. Cruz. The court will take the matter under advisement.
Thank you.
E ku I luna. Please rise. Ua ho'o malolo yamai ne ka aha. Court is now in recess.